imply or sustain valid cause of action. Where injury fails to meet a complaining party, there is no crime, and where there is no crime, there is no subject matter jurisdiction for the court to support a verdict and judgment. None of the testifying witnesses during trial verified that they were both injured by me or my actions in bringing charges against me simultaneously. In fact, proves the prosecution failed to satisfy every necessary elements of the crime, and that the jury, although they heard these essential facts, needed to make a correct determination during the 924 trial, were not fully aware of the magnitude, the absence of the essential elements presents, and they could not consider any other facts or submitted evidence or testimony, and instead, until the prosecution by preponderance of evidence has satisfied the essential elements of the crime. I maintain that the verdict is contrary to the manifest weight of evidence. The jury's finding of fact is not based on evidence revealed during trial, and as a matter of law, the court bears the obligation of overturning the verdict and the judgment in favor of the evidence presented and facts in favor of me, as the prosecution has failed to prove the elements of a crime in this case by preponderance of evidence.
Hey, Mr. Short.
Judge, at this point, it's the court would look at this in the light most favorable to the state. In the light most favorable to the state proved that the defendant was guilty of possessing a controlled substance with the intent to deliver beyond any doubt, much less a reasonable doubt.
Okay, Mr. Shah.
I object.
Okay.
The prosecution refuses to rebut any of the affidavits I have on file, expressly denying that there is no injured party or no constable contract in these matters.
Okay, I've had an opportunity to consider the arguments of counsel, the applicable law, and I remember obviously the facts and circumstances of the case as I was the trial judge. In regards to the judgment notwithstanding the verdict, I do believe that there was sufficient evidence for a jury to believe and that the state was able to prove each and every element of the offenses that were charged, that they were able to prove each and every element beyond reasonable doubt. I do not think that the jury's verdict was contrary to the manifest weight of the evidence. I do believe that the jury's verdict was supported by sufficient evidence for there to be a finding of guilty. Therefore, the judgment notwithstanding the verdict is denied. Okay, your next motion, Mr. Shah.
I object.
Okay.
Is it your judicial determination that the accusation has met an accuser under the penalty of perjury?
I believe that there was sufficient evidence for you to be found guilty. So your motion?
Sir, I'm asking a specific question. Is it your judicial determination that the accusation of the prosecution or whoever has met an accuser under the penalty of perjury?
I'm not quite sure what you're saying, Mr. Shah, but your judgment for notwithstanding the verdict is denied. What's your next?
Sir, you're stopping my objection. I'm asking you a specific question and you're saying you don't understand. It's misleading.
Okay, what's your next motion?
No, my next question is it your judicial determination that the known or unknown jurisdiction by you and the prosecutor, does this supersede the U.S. Constitution, 1787, 1791?
Would you like to have your next motion heard?
Sir, these are my objections. These are facts that are within your knowledge that you withholding. Will the prosecution stipulate that he has not amended the complaint to show jurisdiction or provide a formal rebuttal to my affidavits of fact expressly denying that jurisdiction exists?
Hey, Mr. Shaw, we have a court reporter in the courtroom who's taking down everything you say. So it's all being made a matter of record. So your objections are noted. And could you proceed to your next motion, please?
Sir, I'm asking you, why will you not provide an answer to these specific questions?
Okay, Mr. Shaw, I'm not going to spend another hour and a half debating this. If you'd like to hear.
I'm not debating, it's just a simple question, sir.
Okay, I'm refusing to answer your question. So,
Okay.
your next motion.
The record showed that estoppel by silence and tacit procurement equates to an agreement. The court cannot just sit up and not, and it can not just sit up and withhold knowledge that's within your personal knowledge that's exculpatory. It's a complete denial of due process of law that the court is remaining silent in order to mislead.
Your objection's noted. Thank you.
This next lawful request is a motion to dismiss for failure to rebut affidavits pursuant to the Constitution for the United States, 1787, 1791, and United States versus Kiss. I've submitted a number of affidavits expressing that the nature and the cause of the action has not been provided, nor which system of laws the court is operating under in order to prepare defense. That there is no conscionable contract nor injured party in this matter. And that the prosecution nor any live person or fictitious entity has rebutted any of my affidavits. And the affidavit unrebutted stands as true and is prima facie evidence in this matter. I maintain this case lacks the inherent authority to reach the trial phase and should have been dismissed with prejudice when the court demonstrated its inability to establish jurisdiction for the record by affidavit of fact, and failure to rebut an affidavit of fact that they lack jurisdiction in its totality. The preponderance of unrebutted facts speak for themselves. Therefore, I demand a complete dismissal of all charges with prejudice. As in Illinois, a fact finder may not simply reject unrebutted testimony.
Okay, are you done, Mr. Shaw?
Yes.
Okay, Mr. Shortley?
Judge, Mr. Shah's affidavits really have nothing to do in criminal law, as the court well knows. What the state did prove during the trial was that the defendant that we did have personal jurisdiction over the defendant. He was in the state, he was in the county, he committed the crime in the county, that we had subject matter jurisdiction, and the fact that the items that the defendant had were illegal under the laws of Illinois, and therefore we provided those to the court, we provided those to the jury, and they found him guilty beyond a reasonable doubt of all the elements of the crime.
Okay, Mr. Shaw, Al?
I object as the affidavits are unrebutted. The prosecution has not presented any rebuttal affidavit expressly denying my affidavit or contesting my affidavit that jurisdiction exists, personam, subject matter, and territory. Also, the DeKalb County of Illinois, the municipal DeKalb County of Illinois is not physical. It's political, as well as the prosecution keeps stating law, but refuses to put a wet ink signature in regards to what criminal jurisdiction the prosecution is operating under. These affidavits unrebutted stands as law.
Okay, I've considered the arguments of Mr. Shaw and Mr. Shortley in the applicable law. I do believe that the state was able to show jurisdiction under the laws of the state of Illinois, so the motion to dismiss is denied.
Objection. Is it your judicial determination that the prosecution has proven from the record that jurisdiction has existed?
Yes, I believe that the state has proved jurisdiction in the matter.
Okay, so where is this proof?
It's the proof that was adduced at the jury trial and introduced.
Okay, and what was that?
Well, I'm not going to rehash the entirety of the jury trial, Mr. Shaw.
I'm not asking you to do that. You saying that these facts are in your personal knowledge. I'm asking you where's the proof? Because it hasn't been tendered. I haven't seen it.
Well, you attended the trial, you were there, you saw the evidence again.
So is it your judicial determination that the accusation has met the accuser under the penalty of perjury?
It's my finding that the state established jurisdiction, and that's what your motion contested. So your motion to have the case dismissed because the lack of jurisdiction is denied. What's your next motion?
Objection. Once jurisdiction is challenged, it must be proven. The court has no discretion to ignore the lack of jurisdiction. And a court cannot determine its own jurisdiction. Jurisdiction has to be provided by the prosecution. The prosecution has presented no evidence or rebutted any affidavits in regards to jurisdiction existing, personal, territorial, or subject matter. Is it your judicial determination that this court has jurisdiction over matters of federal question?
I respectfully disagree with your accounting of the law. Your motion to dismiss is denied. Now your next motion.
So is it your judicial determination that the prosecution has rebutted any affidavits?
The court finds that the state established jurisdiction. So what's your next motion?
So I just got a simple question. Is it your judicial determination that the prosecution has rebutted any affidavits I have presented on file contesting jurisdiction exists?
I've indicated that I believe that the state has established jurisdiction.
Sir, via verified affidavit of fact?
The record reflects that the court believes the state has established jurisdiction.
Via verified affidavit of fact?
What's your next motion?
Let the record show that the court refuses to answer the question and that the prosecution has not established jurisdiction via verified affidavit of fact. My next lawful request is a demand for judgment of sentence to be vacated or set aside and dismissal of all matters with prejudice. I maintain that I've demanded that the prosecution present which system of laws that the court is operating under, which jurisdiction the court is operating under. As pursuant to Article 1, Section 8, Clause 17, and Title 28 Judicial and Judiciary Procedures. I also demanded that the prosecution amend its pleas to show jurisdiction, as I have not been in receipt of any documentation from the prosecution stating which system of laws the court is operating under or providing the nature and the cause of the accusation. I maintain that there is no discretion to ignore the lack of jurisdiction. Once state and federal jurisdiction has been challenged, it must be proven. Jurisdiction can be challenged at any time, and once jurisdiction is challenged, it cannot be assumed. It must be decided. And that once a judge has knowledge that subject matter jurisdiction is lacking, he has no discretion but to dismiss the action, and failure to do so subjects the judge to personal liability. Again, I maintain the status as an Aboriginal, Indigenous, Moorish American national, and the jure Islamic Muslim. I affirm my political allegiance to my ancestral state and ancient principles of government and harmony with the American Constitution 1787, 1791. The prosecution, this is not an Article 3 court. I've maintained that the status of the court is a de facto status. It's in fact a corporation who is not entitled to write statutes over my person. None of the laws provided, none of the laws of the state of Illinois have an enacting clause. The court and the prosecution has failed to present what gives the state of Illinois statutes the effect of law without an enacting clause. I maintain that unless and until the allegation of bona fide allegation of jurisdiction has been made, that the court lacks all jurisdiction. The court lacks the three essential elements a court must have: jurisdiction to determine jurisdiction, jurisdiction over the subject matter of the case, jurisdiction over the parties of the case. As all these are lacking, the court is without power to decide the case in any order, decree, or judgment other than a dismissal by such court is void, having only the semblance of appearance of validity, and may be attacked directly or collaterally and vacated at any time and dismissed due to the lack of standing. When ruling on a motion to dismiss for lack of standing, the trial court and the appellate court must accept the petitioner's allegations and all inferences that can be drawn from them as true. I hereby demand that this case and sins be vacated, the judgment be set aside and dismissal of all charges with prejudice, without jurisdiction proven on the record, all orders and judgments issued by the DeKalb County Circuit Court, acting judges and administrator are void under law.
As they worse.
Mr. Shortley?
Because the law that was applied was the Illinois compiled statutes, and that was the law that is the law of the land, the state of Illinois. And the defendant was found guilty under those laws beyond a reasonable doubt by a jury of his peers, and we believe that it should be denied.
Mr. Shaw?
Object. Again, the prosecution has failed to rebut any affidavits expressly denying that jurisdiction exists. In the Constitution for the United States, the treaties made in the United States Code is the supreme law of the land. Is the prosecution willing to stipulate that, or should I understand that the prosecution is saying that the statutes of the state of Illinois has an enacting clause and supersedes the Constitution for the United States?
Go ahead, Mr. Shaw. You don't have to answer that question, Mr. Shortley.
Wasn't playing.
The prosecution is not provided what system of laws the court is operating under. I maintain my objection is that the statutes of the state of Illinois are not law and are not bounding upon my person, and that the state of Illinois is not physical, it's political.
Okay, I've considered the arguments of Mr. Shaw and Mr. Shortley, as well as the applicable law. I do believe that the state is correct and that they were proceeding under state law as well as the United States Constitution. So for the motion for demand of judgment and sentence to be vacated is denied.
Okay, under the United States Constitution?
What's your next motion, Mr. Shaw?
Sir, you just mentioned the Constitution. I was wondering exactly where you were speaking in regards to.
The United States Constitution and Constitution of Illinois.
1791?
I don't know what year the state of Illinois Constitution was enacted.
So
What's your next motion?
So you're claiming to be operating under the Illinois state constitution?
And the applicable laws of the state of Illinois, yes.
No, I said Illinois state constitution, not the state of Illinois.
Yes, the state of Illinois and its constitution.
I didn't say the state of Illinois. I said Illinois state constitution.
Okay, I guess we're gonna have to disagree on what the difference is.
So you're not proceeding under Illinois state constitution.
What's the difference between the Illinois state constitution and the Constitution of the state of Illinois?
The Constitution of the state of Illinois, it has no enacting clause. There is no Constitution of the state of Illinois. The Constitution is Illinois state constitution.
Okay.
And again, I've demanded the nature and the cause of the accusation be presented pursuant to the Illinois state constitution, Article 1, Section 8, pursuant to the national constitution in Article 1, Section 8, Clause 17. Is it your judicial determination that the prosecution has provided this information via verified affidavit of fact?
What's your next motion, Mr. Shaw?
Sir, I need my question answered.
Okay, well, I'm gonna respectfully decline. So what's your next motion, Mr. Shaw?
Sir, why are you not answering questions with where you have this knowledge these facts within your knowledge.
Because I don't even understand your questions, Mr. Shaw, most of them. So what's your next motion?
So you don't understand that I've demanded the nature and the cause of the accusation, which system of laws the court is operating under, to be presented in a verified affidavit of fact by the prosecution,
And I've told you,
expressly denying or contesting my affidavit that jurisdiction exists. This is fraud.
okay, thank you, Mr. Shaw. What's your next motion?
Is it your judicial determination that the known or unknown jurisdiction that by you and the prosecution supersedes the U.S. Constitution 1787, 1791?
What's your next motion, Mr. Shaw?
Sir, I have questions. These are my objections, and you will not come forth with a reasonable answer in regards to none of this stuff.
Okay, your objections are noted for the record. Thank you.
This lawful request is to obtain a copy of the original record of all the proceedings. I was in receipt of the transcript sometime around September 2020. I maintain that it's testimony missing from the record, and there's testimony added to the record. Some include the hearing before Robert Stucker on August 2nd, 2018, the hearing before Judge Doherty, April 27th, 2019. Also, that there is no record of you, sir, of you discharging the public defender's office, Attorney Robert Carlson, nor the appointment of Riley Onken. Also missing from the record is two witnesses who declared treason November 6, 2019 in the sentencing hearing, and myself being the third. Also, the January 2018 report of proceedings is not signed by the stenographer. I maintain that many conversations are missing and some are added. Being this so, I would like to obtain an original copy of the proceedings in order for them to be transcribed by somebody different.
Okay, anything further?
In regards to obtaining the original transcript, no.
Okay, I believe that I had an opportunity to consult with the court reporter who was present in the courtroom, as well as the clerk from the clerk's office. Both have indicated that you've been given the entirety of the transcript and record.
That's impossible. The court docket clearly indicates that there was a special reporter present during these specific times, and I have not received them.
So what are you asking for?
I'm asking that for these specific dates.
What dates? What dates, Mr. Shaw L, are you claiming you do not have transcripts for?
Sir, I'm looking for them. I just read them into the record.
Sitting here, but we're still in the middle of this thing. Damn license. Do you have any of these dates?
Before Robert Stucker, April 27th, 2019. No, before Judge Doherty, April 27th, 2019. Before Robert Stucker, August 2nd, 2018. And also within the record, testimony has been replaced and testimony has been taken out and testimony has been put in. I'm demanding that the original record be turned over as well, so we can possibly have somebody else transcribe this information, because I know for a fact and have affirmed for the record that testimony has been taken out and testimony has been replaced.
Specifically, what testimony are you saying has been taken out, and specifically what testimony?
During the arraignment proceeding, Ms. Stucker exceeded jurisdiction by placing the burden on me by asking, do I know law? And in the transcript, it says something totally different.
Okay.
And it's several other instances that has done occurred specifically just like this.
What specific instances are you talking about? So far, you've not added anything in regards to testimony missing from the record or additional testimony added.
Yes, I have. I just told you that the testimony was missing from the record, that Judge Stucker asked me, do I know law? And something else has been totally added in this regard. and November 6th, during your sentencing hearing, 2 witnesses yelled treason in the courtroom. It's also missing from the record of the November 6, 2019 instance. And I myself was the third. The January 28, 2018 report of the proceeding is not signed by the stenographer.
Okay, the record will reflect that on August 2nd, 2018, the defendant did not appear in front of Judge Stuckert, as he's maintaining that the defendant appeared in front of myself, Judge Montgomery, not Judge Stuckert, as he maintained.
Sir, that's not so. I was in front of Stuckert first, and then me and Swarley walked over to your courtroom that same day. But what I had in front of Stuckert, the hearing that I had in front of Stuckert on August 2nd is missing from the record. And also what I had in regards to the arraignment proceeding the words have been changed in the records.
Well, your request to have a different court reporter transcribe the record is denied. The court reporters are licensed by the state of Illinois, and they listen to me, they provided you with a full, complete, unedited copy of the transcript.
No, they have not. That is not what I received.
What's your next motion?
I object. I demand to be able to receive the original taping, so we can go to an outside transcriber to transcribe, because clearly there's fraud taking place in this courtroom.
Your request is denied. Thank you. What's your next motion? Thank you. You said you had 6 motions. We've done 5.
So sir, what is your lawful request for the denial? Your lawful reasoning for the denial?
As I've indicated, I've had an opportunity to speak to the clerk as well as the court reporter. Both have informed me that you've received the entirety of the transcript.
Objection. You have not stated any law.
So what's your next motion, Mr. Shah?
I'm looking for this other documentation. So, sir, are you alleging that there is record of discharging public defender's office attorney Robert Carlson, appointment of Riley Onken, 2 witnesses who declared treason in November 6, 2019 in the sentencing hearing, and myself being the third? And are you saying that the report of the proceedings is signed by the stenographer?
I'm saying that I've spoken to the court reporter, that I've spoken to the clerk. Both of them have indicated you have received a full and complete unedited record of the transcripts and of the trial and the proceedings.
That's impossible. Sir, I cannot proceed I cannot proceed any further without the full transcript or the original record of the proceedings. I have not received full transcript or the original record of the proceedings. Also, clearly in the court record on April 27th, 2019, there was a stenographer there before Judge Doherty, and there is no record of this.
Okay, what's your next motion?
Sir, I need to know, I need to be able to know, I need the rest of the transcript or to know if I can obtain the original to get my own transcription.
Okay, as I've indicated, you've got the original you've got transcript of all the proceedings that are unedited. What's your next motion?
I object. The transcripts are edited, and they are not the original they are not the original record of the proceeding, and transcripts are missing from the record that was received.
Okay, thank you. What's your next motion? Okay, what's your next motion, Mr. Shaw? Al, you said you had 6. We're at 5.
Yes, sir. Sir, I need some time to go through this. I'm not going to be able to present. I'll probably need a short date to be able to present my next lawful request because I was short notice on this not by agreement hearing and was not able to put my last lawful request, which was the reconsideration, into my file. So I would like to set a short date to hear my reconsideration, as I don't have it with me in my file because I didn't have time to put everything together that I needed due to the short notice of this hearing.
How much time do you need, Mr. Shaw?
I need a day, 1 day, maybe 2.
Well, I don't know that we can get a Zoom writ warrant for it back in a day or 2, Mr. Shaw.
A week.
Mr. Shortley, how much time do you think you need to get a Zoom writ back to him?
Judge, I mean, we can send out a Zoom writ today. If the Department of Corrections, I guess that would be up to them on when they would be able to do it. We've done it in a week before. I'm more than willing to try.
How about May 12th at 1:30, Mr. Shaw? That ought to be plenty of time for you to prepare any additional motions that you have and be prepared for hearing. Mr. Shaw, May 12th then at 1:30. Record will reflect Mr. Shaw is not responding. So, Mr. Shortley, May 12th at 1:30, that'll be for further hearing. Please, Mr. Shaw, I'll file whatever additional motions you have, and we'll just keep the hearing on those. Okay, the record will reflect that Mr. Shaw is not responding. Thank you.